Okay, well, my name is Ian McLennan. I'm Chair of the Board of Trustees for the Howard League for Penal Reform, and it's my pleasure to warmly welcome you all tonight to this lecture. This is our annual lecture held in memory of Lord Parmoor, who died in 2008. But up until his death, he had been a long-time supporter of the work of the Howard League for Penal Reform. He attended events and was well known to staff and trustees. He contributed towards the work and helped the organisation buy its headquarters building in Ardley Road. Because of the generosity of his donation to the Howard League for Penal Reform, we set up this lecture series in his name. Since 2007, Clifford Chance have been hosting these annual lectures, and we are very grateful to them for their continuing support, providing this superb venue for tonight's lecture. This year, the Howard League for Penal Reform celebrates 15 years of legal work with children and young people in prison. I would now like to ask Laura James, who's the director of the legal team at the Howard League, to formally launch the report celebrating 15 years of successful work. Laura.
Thank you very much. As you just heard, this year does mark 15 years of legal work, and you will have seen, I hope, on your way in, a report that we launched today setting out some of that work. And if you don't have it with you tonight, you can get it online. You'll need to read the report in full, but in brief, we provide frontline work. We take over 1,000 calls each year taken by my brilliant legal team, a hotline direct from custody that children and young people under the age of 21 can call to us for direct, expert legal advice. The work we do and have been doing for the last 15 years includes advice and representation to help children and young adults under the age of 21 with a whole host of legal issues, helping them to navigate the complex parole and prison adjudication systems, looking after their safety in custody, challenging things like solitary confinement and other treatment, and also helping them working with social services to ensure their safe release back into the community for a fresh start. In recent years, we have also undertaken participation work to try and make sure the children and young people have a collective voice to change and inform policy and practice. None of this would have been possible without the Children Act case, or as we at the Howard League like to call it, the Howard League Children Act case. The case that, of course, found that the protections afforded by the Children Act do not simply evaporate at the prison gate. And perhaps Sir James will tell us more about that in his speech. However, of course, the tragedy is that the characteristics of children in prison, so eloquently described in that 2002 judgment, are all too familiar today. Yes, there are fewer children in prison, and we've worked hard to be part of achieving that, but they are just as much in need of our support and the need to be seen as children first and foremost today as they were then. So our work is not yet done. So on behalf of the Howard League, I would like to thank you very much for your support so far and in the future.
Well, our first lecture was held in 2005 and was given by Sir Ken MacDonald, QC. 12 years on, and I'm pleased to introduce another great legal mind, the Right Honourable Sir James Munby. Sir James is President of the Family Division of the High Court of England and Wales and has held that post since January 2013. He was called to the bar in Middle Temple in 1971 and appointed Queen Counsel in 1988. He was Lord Justice of Appeal from 2009 to 2013, Chairman of the Law Commission from 2009 to 2012, and has been a judge of the Family Division from 2000 to 2009. Sir James Munby is a leading judicial voice on children and young people. His landmark judgment in November 2002 on the application of the Children Act 1989 to children in prison was the first major legal case brought by the Howard League legal team. Ladies and gentlemen, I'm delighted to allow Sir James to take the rostrum.
Generations of the Crips family have served the state as lawyers and politicians, Meyer Crips, the fourth Baron Parmoor, followed with notable success rather different paths, and although apparently he never spoke in the House of Lords, he made a notable contribution to public life as a staunch supporter of, and in due course generous benefactor to, the Howard League. We gather together tonight to honour his memory. More than 225 years after the death of the noted prison reformer John Howard, the League, whose raison d'etre one might have hoped would long since have vanished, continues its invaluable work as the articulate conscience of a society whose public, official and private consciences seem distressingly atrophied. Never have the words of that great Home Secretary over a century ago seemed more topical. I'm sure you know them very well. The mood and temper of the public in regard to the treatment of crime and criminals is one of the most unfailing tests of the civilization of any country. Judged by that stern test, what right do we have to call ourselves civilized? You do me great honour by inviting me to give this prestigious and important lecture, but I have to confess at once that my credentials for being here this evening are threadbare. The best part of 50 years ago, when I was at university, I exhibited a rather dilettante and short-lived interest in criminal law and criminology. The assize court was more congenial than the lecture room, and I was amongst the very first to take the recently introduced course in criminology. Those were perhaps times for optimism. The Home Office was occupied by one who remains, almost half a century later, still the most distinguished Home Secretary of the last 100 years. And one recalls almost wistfully his warning only a few years later that if the prison population reached 42,000, quote, conditions in the system would approach the intolerable. But my career took me in other directions. I never practiced in and have never sat in a criminal court. And it was only the happenstance of court listing that gave me the opportunity in 2002 to deliver a judgment which was, I like to think, of some public utility and which stands high in the annals of the League. I remember that case with sadness. Towards the end of a lengthy judgment, which had rehearsed much distressing material, I said this: if it really be the case, as the Chief Inspector of Prisons appears to think, that there are young offender institutions which are simply not matching up to what the Children Act would otherwise require, if it really be the case that children are still being subjected to the degrading, offensive and totally unacceptable treatment described and excoriated by the Chief Inspector, and Counsel of the Home Secretary on instructions was not able to confirm that these practices had been stopped, then it can only be a matter of time, as it seems to me, before an action is brought on behalf of a child detained in the YOI, and in circumstances where, to judge from what the Chief Inspector is saying, such an action will very likely succeed. I cannot help thinking that the Howard League has performed a most useful service in bringing to public attention matters which, on the face of it, ought to shock the conscience of every citizen. That was in November 2002. How do matters stand today, almost 15 years later? When launching his annual report in July 2017, the Chief Inspector was quoted as saying that youth custody centres in England and Wales are so unsafe that a, quote, tragedy is, quote, inevitable. And that, quote, not a single establishment inspected was safe to hold young people, close quote. Comment is unnecessary. My focus today, however, is rather different. I ask you to think about children, and that for a family lawyer means anyone who has not reached the age of 18, across the various justice systems in England and Wales, in which from time to time they find themselves enmeshed. These systems, and I use the plural deliberately, are, I have to suggest, far too complex, far too little coordinated, and serving far too many different and often conflicting objectives to be effective in furthering the welfare of children and their families. I was, as you may have read, recently concerned, in every sense of the word, with a suicidal teenager X. I do not propose to discuss the case. it would not be appropriate for me to do so. I refer to it only because it might be thought to exemplify some of the systemic difficulties we face, and because it illustrates some of the problems I wish to address today. For present purposes, all I need to say about X is that she was a gravely disturbed teenager who came from a troubled home and whose mother, her father was dead, had her own difficulties. X was taken into care in accordance with the Children Act 1989, but the various plans approved by the family court did not work. The time came when she needed, for her own safety, to be placed in secure accommodation. No suitable accommodation was available in England, so the placement was in Scotland. Returned to a placement in England, X's behaviour led to her being sentenced by the youth court to a detention and training order and placed in another institution where the intensity and frequency of her self-harming and suicidal actions increased. Eventually, a place was found for her in a clinical setting to which she was transferred by the Secretary of State in accordance with the Mental Health Act 1983. If one thinks about cases like this, and there are far too many of them, even if not all so extreme, it might be thought obvious that we face serious problems to which at present we have no effective solutions. What are the problems, and what can we do about them? The first question, I have to admit, is much easier to answer than the second. What then are the problems? I believe there are 7, and I will take them in no particular order. The first problem is that cases involving children are spread across the jurisdictions. Cases where a child is put in the care of a local authority and disputes in relation to what until recently were called residence and contact are heard in the family court or the family division of the High Court. Criminal cases where a child is being prosecuted are heard in the youth court or the Crown Court. Where a child is seeking asylum or is subject to immigration control, the case is heard in the first-tier upper tribunals of the Immigration and Asylum Chamber. Where a child is subject to the provisions of the Mental Health Act, the relevant tribunal is the Health, Education and Social Care Chamber. Although there are some mechanisms in place for the sharing of information between some of these jurisdictions, these mechanisms, even when they work, are confined to sharing of information. There are no mechanisms to facilitate collaborative, joint, or even joined-up decision-making. Moreover, because of the way in which the professions are organised and the judiciary deployed, there is too little understanding across the jurisdictions of how the others operate. Let me give an example. Although the jurisprudence analysing the tensions between and explaining the different functions of the family and the asylum immigration jurisdictions is, it might be thought, not merely long established but clear enough, misunderstandings on even the most basic points are still rife. Or take the interactions between the family courts and the criminal courts. On occasions, and I emphasise I am not here referring to X's case, the perception of a family court is that the sentencing decision of the criminal court is not helpful in furthering the family court's planning for a disturbed teenager. On occasions, one finds the two jurisdictions simply do not marry up sensibly. I remember a case some years ago where both the family court and the youth court had made orders providing for the involvement of the relevant local authority in the child's life. The child lived in London. The family legislation decreed that the relevant authority was the London Borough of A. The criminal legislation that the relevant authority was the London Borough of B. Did the child benefit from having the services of two local authorities? No. The answer, as you may have guessed, was no. The involvement of two authorities was simply a recipe for confusion leading to inertia. The second of the 7 problems I want to talk about derives from the fundamental constitutional principle explained by Lord Scarman in a case called A and Liverpool City Council back in 1982, namely that, and I quote, "The High Court cannot exercise its powers, however wide they may be, so as to intervene on the merits in an area of concern entrusted by Parliament to another public authority." Close quote. For present purposes, this has a number of important consequences. One is that absent statutory provision to the contrary, the ambit of judicial decision-making is constrained by the extent of the resources made available by other public bodies. So the family court cannot direct that resources be made available or that services be provided. It can merely seek to persuade. Another consequence coming closer to home is that if, for example, a child is detained under a criminal sentence or in accordance with the Mental Health Act, the decision as to the child's release lies not with the family court, but with the Secretary of State in the one case, or the treating clinicians, or the Health, Education and Social Care Chamber in the other. Thus, the family court can make a care order in relation to the child, but the court's functions in relation to her placement and welfare inevitably remain largely in suspense pending her release. The same principle applies, of course, as between the family court and the local authority. When a care order is made, it is for the local authority to formulate its care plan and for the judge to approve it. What if there is disagreement? The answer, it has been said, is this, and I quote, "It's the duty of any court hearing an application for a care order carefully to scrutinise the local authority's care plan and to satisfy itself that the care plan is in the child's interests. If the court is not satisfied that the care plan is in the best interest of the child, it may refuse to make a care order. It's important, however, to appreciate the limit of the court's powers. The only power of the court is either to approve or refuse to approve the care plan put forward by the local authority. The court cannot dictate to the local authority what the care plan is to say. Thus, the court, if it seeks to alter the local authority's care plan, must achieve its objective by persuasion rather than by compulsion. That said, the court is not obliged to retreat at the first rebuff. It can invite the local authority to reconsider its care plan, and if need be, more than once. How far the court can properly go down this road is a matter of some delicacy and difficulty. There are no fixed and immutable rules. It's impossible to define in the abstract or even to identify with any precision in the particular case the point to which the court can properly press matters, but beyond which it cannot properly go. The issue is always one for fine judgment, reflecting sensitivity, realism, and an appropriate degree of judicial understanding of what can and cannot sensibly be expected of the local authority." End of quote. The principle, of course, is impeccable, but all too often the consequences are unsatisfactory. A court charged with the duty of furthering the child's welfare is denied the necessary tools to do so. These difficulties are made more complex by the third problem, the way in which our public finances are organised. A salutary and long-established principle is that public money is to be spent by a public sector body only for the proper purposes of that body and in accordance with what has been decreed by Parliament. Again, the principle is impeccable, but sometimes the consequences are unfortunate. Typically, the families and children who find themselves before the courts are the victims of multiple difficulties and deprivations: economic, social, educational, employment, housing and health, sometimes both physical and mental. Ideally, we should be treating such families holistically, but too often this is made more difficult or even impossible because responsibility is spread across too many agencies and too many budgets. And there is too often a tension between attempting to solve today's problems, the responsibility, let us say, of a local authority, and the longer-term benefits which will flow to other agencies, for example, those involved with criminal justice and health, if the problem is solved. Even within the ambit of local authority responsibility, there are difficulties created by the ways in which local authorities organise their services and budgets. A unitary authority may have responsibility for children's services, adult services, education and housing. But if the focus of the proceedings in court is on the child, as where the local authorities embark upon care proceedings, it can often prove frustratingly difficult to engage and motivate the other services, even where, for example, the child's parents are themselves, because of their own difficulties, entitled to the support of the local authority's adult services. These difficulties are also, of course, exacerbated by the fourth problem, the all too frequent lack of sufficient resources. This problem predates, though it has been made much more acute, by the current age of public sector austerity. The family court is still sadly lacking in the resources, for example, adequate and effective special measures, the provision of intermediaries, which are essential if the vulnerable, whether children or adults, are to be enabled to participate properly in the process. These are not merely things mandated, it might be thought, by Articles 6 and 8 of the European Convention. Even more important, are they not mandated by any acceptable concept of what justice and fairness demands? But there are, of course, many other instances where the lack of resources is seriously hampering the work of the family courts and the criminal courts. Probably the most egregious, because it so directly impacts on the ability of the courts to further the child's welfare, are the serious shortages, regularly all too apparent to too many family judges, of the secure accommodation and the mental health services, whether residential or in the community, needed by ever-increasing numbers of disturbed, sometimes very disturbed teenagers. The fifth problem reflects the division of responsibilities across Whitehall between different departments and ministers in matters affecting families and children. The Department for Education, the Ministry of Justice, the Department of Health, the Home Office, the Department for Work and Pensions, the Department for Communities and Local Government, even the Department for Digital Culture, Media and Sport. A recent important announcement of extra funding for family drug and alcohol courts, a topic to which I'll refer in a moment, was made by the Parliamentary Undersecretary of State for Sport and Civil Society. Thank you. All these departments have roles to play. As an aside, I was completely unaware, despite the best part of 4 years in my current, best part of 5 years in my current role, of the involvement of the Department for Digital Culture, Media and Sport until I read the recent announcement. It is perhaps an intriguing commentary on how Whitehall is organised that there is no department and no Secretary of State whose title includes either the word families or the word children, although there is a junior minister, the Minister of State for Children and Families, in the Department for Education. In some areas, policy and justice are located in different departments. Thus, at the risk of some oversimplification, criminal policy rests with the Home Office, just as family policy rests with the Department for Education, while both criminal justice and family justice fall within the remit of the Ministry of Justice. Even when this system, if that is a remotely appropriate word, is working with well-oiled efficiency, it is rarely capable of speaking speedily or with a single voice, let alone decisively and effectively. The sixth problem reflects the tardy and even now only incomplete incorporation into our domestic law of the requirements in Articles 3, 1 and 12 of the United Nations Convention on the Rights of the Child. Article 3 provides that in all, quote, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities or legislative bodies, the best interests of the child shall be a primary consideration, close quote. Article 12 provides that, and I quote, States party shall assure to the child who is capable of forming his or her own views, the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. For this purpose, the child shall in particular be provided the opportunity to be heard in any judicial and administrative proceedings affecting the child, either directly or through a representative or an appropriate body, in a manner consistent with the procedural rules of national law. Close quote. This links in with another problem, our slowness in accepting the equally profound implications of the undoubted fact that the child has, quite distinct from and sometimes in conflict with his or her parents, the important procedural rights guaranteed by Article 8 of the European Convention. It's a saddening commentary on our law. It was not until 2011 that the Supreme Court was able to articulate the fundamental principles explained in a case called ZH Tanzania, which have had, and not before time, such a profound effect on so many areas of the law which impact on children. In the family courts, the rights and interests of the parents often conflict with those of the child, most obviously perhaps when the plan is to remove a child permanently from parents for adoption. Both parent and child have rights to, quote, private and, quote, family life, which are protected by, are entitled to respect in accordance with Article 8. There is now a detailed, subtle and well-established jurisprudence explaining how these rights are balanced. And the application of that jurisprudence is a matter of daily practice in family courts. In other places, for example in the criminal courts and in the immigration and asylum chamber, the issues tend to be rather different. Often parent and child share similar interests and find themselves together in conflict with some opposing public interest. In the criminal courts, the public interest in imprisoning offenders, even if they have childcare responsibilities. In the immigration and asylum chamber, the public interest in enforcing a fair and proper system of immigration control, even if that may lead to the separation of parent and child. Here, I fear the issues were inadequately appreciated until the decision in ZH, and even now the jurisprudence is neither as well developed nor as deeply embedded in daily practice as might be thought desirable. The fact that even now the United Nations Convention on the Rights of the Child has not been incorporated as such into our domestic law, its statutory application into our law has been both piecemeal and partial, says much about our system, and it is not, I suggest, a matter of pride. The seventh and final problem is one common to both the criminal and family courts. Unlike the civil courts, which essentially look only to the past, the criminal court and the family court look both to the past and to the future. To the past to help determine what should happen in the future. That is all to the good, but too much of the time the exercise is still limited to determining what is the appropriate disposal for the case, what is to happen to the prisoner or to the child in future. In the family court, where the welfare of the child is by statute the court's paramount concern, it is all too easy to focus on the child's future without paying adequate attention to what it is that has brought the court's involvement, to what it is that has brought about the court's involvement in the first place. And especially with younger children, that has to do almost exclusively with the parent, not the child. Well, typically, the problems are those of the parent, not the child. So far too little time is spent identifying the underlying problem, or more typically problems, and then setting out to find a solution for the problems. In a sentence, family courts, and where children involved, surely also criminal courts, ought to be, but usually are not, problem-solving courts. Now, what this brief canter through an immensely complicated landscape has, I hope, brought out is the pressing and imperative need to do something across all these disorganized systems. Systems which, to repeat, are far too complex, far too little coordinated, and serving far too many different and often conflicting objectives to be effective in furthering the welfare of children and their families. Something, indeed much, must be done, but what? The history of law reform over the last few centuries shows that significant changes, especially those to do with institutional reform, often take not years but decades to achieve. Lest you think me unduly pessimistic, can I remind you of just how long it took to introduce the unified single-family court, recommended in 1974 by the late Sir Maurice Finer, acknowledged by almost everyone of any sense as being an obvious necessity, yet not established in 2014, precisely 40 years later. And I fear that significant institutional changes to overcome, for example, the first of the problems I've identified, the spread of cases involving children across so many jurisdictions, would even in normal times be almost impossible of achievement, however desirable in themselves, given the fragmentation of power and responsibility in Whitehall. So much must, I fear, be left to the initiatives of the judiciary and the third sector. That much can be achieved, largely without the initiative or intervention of Whitehall, is demonstrated, I think, by the great success of FDAC, the Family Drug and Alcohol Courts. the first and triumphantly successful example, and one judicially driven, of problem solving in the family court. Fundamentally, the approach adopted in FDAC is a combination of judicial monitoring and a multidisciplinary therapeutic intervention tailored to meet the needs and problems of the parents in care cases where the underlying issue is parental substance abuse. Very careful independent academic research has proved that FDAC works and that FDAC saves money. More children are reunified with parents if the case has gone through FDAC than through the normal family court, and there is significantly less subsequent breakdown. FDAC increases the sum of human happiness and decreases the sum of human misery, and it saves the local authorities who participate significant sums of money, £2.30 to be precise, for every pound spent. Where in current circumstances outside a Ponzi scheme can you get such a return for your investment? Another more recent project, which has already proven great success, is PAUSE, where the objective is to break the pattern we see so frequently in the family courts of mothers who find themselves the subject of repeated applications for the permanent removal of each of their successive children. The dismal record is believed to be held by a woman who has lost 19 children to the care system. 19. Again, as with FDAC, the approach is founded on identifying and then tackling the often numerous underlying problems and difficulties which have confronted the woman. In short, helping her to turn her life round. There are other projects adopting similar approaches. I believe that this points the way forward to what, in my view, is so urgently required, a fundamental rebalancing of the family court towards what ought to be its true role as a problem-solving court, engaging the therapeutic and other support systems that so many children and parents need. But the concept of the problem-solving court surely has to extend far further than that. Not least, it might be thought, into the processes of the criminal courts as they impinge on families, whether the child or the parent. This is particularly important in cases where the court, whether the family court or a criminal court, is struggling to deal with a disturbed teenager. In these uniquely complex cases, the children have themselves become part of the problem. So a problem-solving court must grapple with the underlying problems and difficulties, not just of the parent, but also of the child. In short, with the underlying problems and difficulties of the whole family. So what we need is a problem-solving court for the whole family. Can a criminal court, can the youth court satisfactorily fulfill that role? Is it not in truth a role better suited to a revamped family court with an enhanced jurisdiction? However, a court which is to be an effective problem-solving court has to have available to it the necessary tools, including critically access to therapeutic and other support systems for the families involved. In the case of FDAC, those tools are, generally speaking, to hand, because each FDAC reflects a local alliance in each of the relevant agencies who have voluntarily come together to share their resources in what they recognise has to be a common endeavour. But what is feasible in the context of FDAC may be impossible to achieve in other contexts. So we need to find ways of working around the problems caused by the rule in A v Liverpool City Council. This will probably require primary legislation and will certainly require ingenuity, but it ought not to be impossible. There are already statutory provisions which, for example, empower a family court to direct what services a local authority is to provide. Thus, I take one at random. Section 38(6) of the Children Act enables the court to direct an assessment at the expense of the local authority of a child who is subject to care proceedings. Although this particular power is narrow in scope, in substance it applies only to an assessment and not to therapy, and only to the child and not to the parent. It shows that there can, if Parliament chooses, be exceptions to the Liverpool principle. The need for the practical implications of the Liverpool principle to be revisited as a matter of appropriate urgency is surely obvious. If cases such as X are to become things of the past, and if the courts are to be properly equipped for their vital problem-solving role, more effective tools are required than the present blunted weapons of persuasion and shaming. In an ideal world, we would be giving very serious consideration to sweeping jurisdictional changes, bringing order to disorder by incorporating many, if not all, of these jurisdictions within the expanded jurisdiction of family court. Why, for example, could the youth court not be amalgamated in an expanded family court where the process would no longer be criminal and the emphasis could be on problem solving in the true sense, and as I've suggested, for the entire family, rather than on punishment or so-called rehabilitation for the child in the custodial estate, so excoriated by the Chief Inspector. We cannot, of course, wait as the decades pass while the argument gains traction, but could not more be done in the interim by the judges and in the criminal context by the Crown Prosecution Service? For example, a few points taken at random: improving understanding across the jurisdictions of how the others work, introducing mechanisms to facilitate collaborative, joined-up or even joint decision-making, in particular ensuring by appropriate judicial ticketing and cross-deployment, the judges with expertise and experience in the family court can also sit in the youth court, the immigration and asylum chamber, and the health, education and social care chamber. In cases where there are parallel proceedings in different courts involving the same child, listing the cases simultaneously before suitably cross-ticketed judges. There's nothing particularly novel or difficult in this. I have myself on a number of occasions sat simultaneously in the family division and the administrative court to hear a pair of cases relating to the same family. Those are matters for judicial initiative. But is it too much to suggest with all appropriate diffidence that the Crown Prosecution Service might wish to reconsider existing prosecuting policy in relation to children? I do not, of course, go as far as to suggest that age alone should immunise children from the appropriate application of the criminal law where there has been really serious offending. However, in less serious cases, it is legitimate to ask what advantage there is, either to the child or to the child's family, or indeed society at large, in invoking a criminal process in preference to a family court process, especially where the family court is already engaged in careful analysis of and planning for the child's future. Many of the problems which I have identified require solutions which necessarily have to reflect no doubt tough political decisions born of a political will to act. In relation to that, I've said as much as is appropriate for a serving judge, but I can properly end with this plea: that more be done to embed Articles 3 and 12 of the United Nations Convention and Article 8 of the European Convention in our law, and even more so in practice across all the jurisdictions which impact on children and their problems.
Thank you. Well, we've got about 15 or 20 minutes for questions. We've got some roving mics in the room. Can I ask that if you want to ask a question, when you get the mic, you give your name and the organisation that you may be representing. Got a question at the front here?
Thanks. Joshua Rosenberg. Can I ask you to expand a little bit, Sir James, on your suggestion that the Crown Prosecution Service should reconsider its prosecuting policy? I think you said that this should apply in less serious cases. Can you give me some examples of the sort of cases where you might think it appropriate for a prosecution not to take place, cases where there is currently a prosecution? What are the cases then that would benefit from dealing with it on the family, by family judges in the family court rather than by criminal prosecutions?
Well, I'm not going to be drawn into specific detail. I was careful to distinguish between the general run of cases and really serious cases. I mean, the kind of case I have in mind, and I'm not going to give examples, is the kind of case where one has to ask oneself, well, what has been achieved by convicting this child, giving this child a criminal record, subjecting the child to a process which is unlikely to do very much good for the child, particularly if there are other processes available, for example, in the family court, which can be of more use. And I mean, this is a societal issue. It's not just an issue. This is not sentimentality for delinquent children. It's a societal issue. And what benefit is society getting by sending children to enormously expensive institutions, which I imagine still cost, they used to cost much more than sending a little child to Eton, where the outcome is so unhappy, and particularly if the institution is one of the kind described by the Chief Inspector.
Question in the middle, aisle here.
Thank you. Sarah Curtis, former juvenile youth family court, never sat in a criminal court. I'd just first like to applaud everything that's been said tonight, but to ask where we could look at examples from other nations, starting perhaps a bit from Scotland, not completely, but from other nations, and how that could be put to our politicians, but they're probably against other nations now, but would that be helpful?
Well, you correctly touch upon Scotland. I must be careful what I say about Scotland. In many ways, its system is a distinct advance on the English system. And I think I'm right in saying that the fundamentals of the Scottish system derive from a report by the late great Lord Kilbrandon way back in, was it the 1970s? So they are decades ahead of us. I'm slightly tempted in what I say because in its purely family jurisdiction, the Scottish system, although it has advantages in bringing crime and family together, in its purely family context, it is not something which has tended to find favour with policymakers in England. In terms of other foreign examples, I have put my hands up and confess virtually complete ignorance. I'm quite sure there are foreign examples. And for example, FDAC is an import from America, and in fact from the Deep South, and that is a very good example of how we've got to look abroad, wherever it may be, for examples. I'm quite sure that if one conducted a sort of trawl through the systems in a significant number of foreign countries, one would be left, A, with a powerful impression that our system is really rather old-fashioned, to put it politely, and B, be left with a large stock of very useful ideas for how the system might be improved. One of the problems is that there is simply, outside, I suppose, the Law Commission, and I'm party pre on that, because I was once, as you can tell, the chairman of the Law Commission, because of the complete fragmentation in Whitehall, and because Royal Commissions have now fallen out of favour, there's actually no mechanism, we have no mechanism now in central government for exploring these fundamental cross-jurisdictional issues of basic policy. I could well imagine, a proposal that there should be some root and branch exploration of possible changes in the present system, and a suggestion that we might usefully learn from foreign jurisdictions. The Whitehall process would take us through scoping studies and scoping studies and scoping studies for further scoping studies. And 3 years down the line, one would have done a lot of talking and achieved absolutely nothing. Unhappily, this is the kind of, and this is why I referred in passing to the third sector, this is unhappily the sort of thing which has got to be done by the third sector. Whether by a body like the Howard League, whether by some group of academic researchers funded by the Nuffield Foundation, for example, I don't know, but I'm sure that the work required to be done, I'm sure that it wouldn't take an academic researcher very long to trawl through international practice in many, many other countries and fairly quickly come up with some very powerful ideas. But forgive me, beyond providing the nostrum, I can't actually answer your question.
Lucy.
Thanks. My name is Lucy Scott Moncrief. I'm a trustee of the Howard League. I'm also a mental health tribunal judge. I wonder whether, I mean, your comment about the Crown Prosecution Service, there's a very well-established diversion from custody and diversion from criminal justice for people who may be more appropriately dealt with under the mental health jurisdiction. It seems to me quite likely that the CPS might be willing to look at diversion, as it were, from prosecution, where there is a more suitable alternative. I don't think that was a matter of legislation. That was a matter of people of goodwill getting together.
No, I think a lot of these things can be dealt with without legislation.
Yeah.
Particularly trying to get more joined-up thinking, cross-jurisdictional thinking, working together, joint planning, joint decision-making. I'm sure a lot of that is feasible. And a lot of it is happening already, at least in theory. What I do wonder is whether we couldn't have a more radical approach, where we could actually have cases heard together at the same time by suitably cross-ticketed judges. I mean, if I may say so, what you omitted to tell the assembled host is you're an immensely experienced, very distinguished family lawyer. I mean, you are precisely the kind of person who, with appropriate cross-ticketing, would surely be eminently suited to sit hearing two cases, one a mental health case and the other a family court case, and relating to the same child. There's a tremendous amount of judicial talent out there. And one of the problems with the system is that we've all tended to operate in our own little silos. And very few people operate outside the silo. Very few people understand what goes on outside their silo. And as we move forward into a new era, I mean, judicial cross-ticketing, judicial deployment across the jurisdictions is being seriously talked about for the first time ever. And, for example, cross-ticketing between the tribunal's judiciary and the court's judiciary is becoming a reality. I think we need a bigger push on that. What experience has taught me is that these things tend to be the result of initiative by individuals. And for example, there is a protocol dealing with the sharing of information between the Immigration Asylum Tribunal and the family courts. And that, as I recall, was very much the consequence of initiative taken by the then judge in charge of the immigration system, which I very happily picked up and ran with, and the protocol, which was the product of that, was a protocol signed jointly by him and by me. But once the initial push has gone, the protocol remains there, but there's an increasingly sort of atrophying thing which doesn't work in the real world.
Okay, question from Nick Hardwick.
Thank you. I'm Nick Hardwick. I was the Chief Inspector of Prisons and am now Chair of the Pro Board. My question is about whether you think issues of transparency and openness, how they relate to get in the way or assist the sort of reforms you're talking about in juvenile justice. So on the one hand, I know you've spoken about the need for greater transparency in the family courts. On the other hand, you might argue that, say, for juveniles who've reached maturity, it's important that their identities continue to be kept confidential. And how what set of principles squares those different requirements, and whether, if the system was more open, that might assist the case for reform.
Well, there's a terrible tension here. I mean, the more that these systems are open, the more they're subject to public understanding, public scrutiny, and public criticism. And often it's the public criticism which actually is the motor, which eventually leads to the exercise of political will. So in that sense, transparency is a good thing. And it's something I've argued for very strongly in the family context. You're probably aware since I became president. On the other hand, as you've identified, the problem with transparency is that if you identify the children, if you identify the families and the children involved, that is causing potentially enormous damage, particularly if it's recorded in the local newspapers and in the modern world of perpetual retention on the net, in social media, these things will come back to haunt children, and we know that there are a lot of people forget the family courts, forget the courts altogether. A lot of people are very concerned about the extent to which children today are exposing themselves to future problems because of their, what is said to be by some, excessive use of social media. And they simply don't realise the implications of what they're doing. I mean, the simplistic answer is to say we want more transparency about the process, we want more transparency about the cases, while preserving the anonymity of the children and the families. That is sometimes easier said than done. If you live in a very big metropolitan area and your case, in a sense, is distressingly similar to hundreds or thousands of other cases, you can usually publish a vast amount of detail without anybody working out who the family is. If the family circumstances are unusual, if you live in a much smaller community, it's much easier for people to look at what is thought to be an anonymised redacted report and say, oh, that actually refers to X. And there are two problems. One is that those who actually know the family will find it easier to identify who the anonymous report's referring to than the outside world. But quite apart from that, there's a real problem with the outside world. And we have at present a very astute, very interested and extremely able Press Association reporter who covers the family courts in London. And he is very interested, from a journalistic professional point of view, in the whole transparency agenda. And it was rather sobering because about a year ago, it wasn't one of my judgments, about a year ago he told me that one of my brethren handed down a judgment, anonymised and redacted. It had taken him 2 minutes by searching on the internet to work out who the family was. So there's a terrible tension there. I mean, in principle, I think the answer is more publicity for what's going on, more publicity, more discussion about the facts of cases, particularly if the result of publishing the facts is to stir the public conscience. The simplistic answer is all that while keeping the family anonymised. And I would be interested, for example, I mean, I refer to X. I've given 5 judgments in the X case. They're all in the public domain. I was very careful to strip out what I thought was any identifying information. In a sense, I mean, without being unduly flippant, I'd be very interested to know whether somebody reading those 5 judgments, how long it would take them to identify who X is and where X lives. I'd like to think that nobody would meet the challenge. I have a horrible feeling that probably somebody pretty quickly would work out.
Okay, a question up here on the right.
Hi, my name is Leanne Peters. I'm from the U.S. studying the UK criminal justice system, specifically re-entry. Going back to her question over there about, children and youth services. I'm not sure if I misheard you that you don't have departments here specifically for children or families, really, but we have, I'm from the New York tri-state area, and in New Jersey where I was raised, we have, it's called DYFS, Division of Youth and Family Services, and almost every other state we have CYS, Children Youth Services. Do you have something like that here, or did I mishear that? I'm not really sure about that.
Well, we have a large number of agencies.
Is that...
The local authority, which is the primary public agency involved with children, but that's in the non-criminal context.
Right.
There are other agencies, they keep on changing, I can't remember what the current title is. Used to be the Youth Justice something, which are concerned, which is a public agency concerned with children and families in the criminal justice system. And so that the confusion, the multiplicity of bodies and courts, I refer to in the jurisdictional context, tends to be reflected in public other non-judicial public agencies involved with children and families.
Okay, we've got a cluster of questions from the centre here, so can we start? Would you all like to give the two or three that want to ask questions, do you want to give them all in one go, so to speak? So we have the first one. And can the second person...
Hello, my name's Alice. My child entered care under Section 20. I'd like to respond to the lady from New York Tri-State. My son went to school in one borough, our doctor was in another. We lived in a third local authority, he was sectioned into a fourth. Our local authority weren't aware of our existence or any of our difficulties till the day he entered care. So this fragmentation of the landscape has very serious implications. I'd also say that I attempted to raise these kinds of issues with the Department of Education. I wrote many times to the Minister, and eventually I got to meet some people in the Department of Education, and it was a quite difficult meeting because I wanted to talk about issues which they didn't want to talk about at all. And eventually, when I was being shown out, a lady whom I think was trying to be helpful said to me, you know, you may think that the Department of Health has some clout here. Actually, we own this area. We own children in care. I think she was actually trying to explain to me how things worked, but I found it really, it was dreadful. And in addition, I was kicked off to some inquiry run by, it's actually into SCIE, which is, they're running a report into the mental health of looked after children. And the Department of Education said the Department of Health would have the details of who to contact. I had to do a Freedom of Information request to find out the details of who to contact. And actually it was the Department of Education. So it is really, it's horrendously fragmented. It couldn't possibly work. It's a system set up for chaos. It needs comprehensive overhaul.
Well, that, I would say, is a very powerful exposition of the point from the point of view of what they call the customer or the user. Just take the care system. There are at least 3 government departments who are involved. There's the Department for Education, which sets the policy. There's the Department for Communities and Local Government, which is responsible for local authorities. And there's the Ministry of Justice, which is responsible for actually putting the cases through the judicial system. So there's complexity at that level. There is a fundamental problem, and this is buried deep in the roots of central and local government history in this country. I think I'm correct in saying that in England there are 152, and in Wales there are a further 22 local authorities who have childcare responsibilities. So across England and Wales there are 174 local authorities who share responsibility. Now, if you're living in the depths of, let us say, Northumberland, it doesn't make that much difference because Northumbria is a very big place. If you're living in London, there are 33 local authorities in London who are responsible for childcare. That is the City of London and the 32 boroughs. And in many parts of London, the boundary between adjacent boroughs goes down the middle of the same public highway. So I think, for example, I have an idea that, if you go down the road to Clapham, on the right-hand side it's Lambeth, on the left-hand side it's Southwark. And that is precise, and you have similar problems, similar issues, for example, in the Black Country, where there are a large number of authorities. You have similar problems in Greater Manchester, where there are a lot of authorities. And it's not at all difficult in that situation to find yourself, for a family to find themselves, dealing with a number of different local authorities who've become involved with them for different purposes in different contexts. And joined up record keeping, joined up thinking, joined up planning, joined up support for families are all casualties of this chaotic system. And one great unmentionable, and it's unmentionable because it actually goes to very fundamental political issues about the relationship between central government and local government, is in the modern world is actually sensible, having 174 different local authorities dealing with care cases.
Okay, can we take any questions?
My name's Anne Neal. I'm from Legal Action for Women, working with mothers who are fighting against being separated from their children. Just wanted to make two observations. One is you spoke about the problems in the family court needing to address problems for how people got there in the first place. And you referred to the focus on the future. Time and time again, we've seen cases where parents have been told there's the possibility of future emotional harm, in inverted commas, not based on actual harm that's actually happened, but a supposition of harm that may or may not happen in the future, but very draconian decisions are made on the basis of that supposition. And, you know, to draw an analogy, you wouldn't say you might have a car accident, so, you know, don't buy a car. And I think that that's a very serious problem. The other observation I'd like to make is that you referred to mothers with repeat children being taken away. I think the statistics are that 1 in 4 mothers who have repeat children taken away have themselves been raised in care, which one is a terrible indictment of the care system, because children are taken into care supposedly in order to improve their life chances, but if then what happens is then when you yourself have a child, that child is taken into care, it's perpetuating that harm. And it's also, mothers are told, well, you were in care so you don't know how to be a mum. So how does that, you know, what does that say about the care system?
Well, the modern care system in terms of legislation dates from 1989. The legislation came into force in 1991, so we've had it now for 26 years. We've got to a point where we're now seeing the 3rd generation of mothers going through the care system. I mean, the mothers, the grandmothers, the mothers, and now the children. And it is a pretty dreadful indictment of a system, as a system produces that intergenerational, continuing cycle of deprivation of solutions which aren't solutions at all. And I mean, another topic one could expatiate upon at length, and I touched upon it in the great case 15 years ago, is all sorts of information we have about children in the care system, is that they have very poor life chances. They are disproportionately represented in the prison population, they're disproportionately represented in the mental health population, their educational achievements are less, and so on and so forth. I mean, my approach has always been very simple. I said this one of the earliest judgments I ever gave. The only justification for the state intervening is if the state can do a better job than the parents. It's a very simple proposition. And we have to ask ourselves, is the state actually doing better than the parents? And I suspect many people have views on it, and I suspect many of the views will be uncomfortable. I'll only add this, and I've said this before publicly. When we look back from the perspective of today to what previous generations were doing, in the not too distant past, if we look back to, for example, to the way in which adoption was used in this country in the 1960s, if we look to the emerging scandals of the export of our children in the 1950s and 1960s, even later, to parts of the Commonwealth, we now look back on that with shame. And that is a very chastening fact, because this is not long-distant problems. This is not the 21st century laughing at the ignorance of the 18th century. This is the early 21st century, looking at what was going on in the late 20th century. And if one transports that to the future, unless you believe that we have come to the end of history, and that doctrine, that dogma, survived about 6 months after it was first articulated with the fall of the Berlin Wall. I mean, the question I always ask myself, and the answer is rather uncomfortable, is what will they be thinking of us in 30 or 40 years' time? And if we're honest with ourselves, we have no reason to be confident that they'll be thinking very well of us in 30 or 40 years' time. Probably the reverse. And I've said this before, and I believe it very profoundly. It's an unsettling thought. The one thing we must all have if we're involved in any of the assistance as professionals is the humility to realise that we may very well be getting it wrong, and the humility to recognise that whatever we do, even if we're doing the best we think we can do by our own lights in light of current knowledge and expertise, it is likely we'll be ridiculed or worse in future. So, I mean, there are very serious problems. And I'm not, if you'll forgive me, going to get involved in some of the detail of the other points you've raised. But I think we do. And the same surely goes for the criminal justice system. And I speak there from a position of complete ignorance. My knowledge of the criminal justice system is largely based upon 2 judgments I gave, one in relation to the Howard League and the other in relation to mother and baby units. All I can say is that in my defence is that having given the Howard League judgment, I then made it my business to go and visit a large number of YOIs to see what life was actually like in them. And likewise, I visited a significant number of mother and baby units to see what the reality was there. But I suspect that what I'm saying about the humility which I think people in the family justice system have to have would apply equally to the criminal justice system, and I suspect other systems.
Thank you very much. We'll draw questions to a close now.
I've been waiting with the mic. Can I ask my quick question?
Okay.
Yeah. Caroline Willow from Article 39 Children's Rights Charity. In the same year that the Children Act 89 came into force in 1991, we ratified the Convention on the Rights of the Child. So my question is in 3 parts. Firstly, Sir James, what do you think's keeping us from ratifying, from making the convention part of our domestic law? Secondly, what would it take to make that big shift? And thirdly, what do you think children have to gain from the convention becoming part of our domestic law?
Well, the answer to your first question is the very fact it hasn't been implemented across the board in, 26 years, is eloquent that governments of all complexions, this is not a political point, or let alone part of a political point, see that the implications in terms of what they see as public administration of implementing the convention are just too terrible to contemplate. And it is now in force in relation to the immigration asylum context. As a result, I think it was at section 55 in one of the recent acts, but that was a long, long battle. Because the reality is, if you actually take Articles 3 and 12 of the Convention and Article 8 of the other conventions seriously, they have very serious implications, not just in terms of judicial decision-making, but in terms of administrative decision-making. And that, I suspect, is why it's never been introduced. Now, your second question was...
What would it take for us to bring it into the next?
Well, it requires the long haul. It requires people who are prepared to go on and on and on, saying this simply cannot be tolerated, this has got to change. Because if you say it long enough and loud enough, eventually people will start taking it seriously. But one of the most fascinating books I ever read when I was chairman of the Law Commission was a very amusing but really rather chastening book by a historian, who took, I think, a dozen great law reform campaigns of the 19th century and described how long it took to persuade government to do anything. And one was slavery, one was man traps, one was sending boys up chimneys. And whatever you try and do, it takes decades because the vested interests it's always much easier giving reason for not doing something than for doing something. And what I'm afraid the experience of law reform demonstrates is that unless you have a happy correlation of fleeting view between politicians and law reformers, it's a matter for the long haul. So the answer is just keep on at it. The day will come. I don't live to see it probably. The day will come. And the crucial thing is to have faith that they will come. And then the third thing is, well, in my book, it'll be of enormous benefit to children in all sorts of contexts, including those we don't at present really think about. And what is interesting is ZH Tanzania, which I referred to, and that was all to do with the extent to which children in asylum cases were to be treated as individual actors in their own rights, as opposed to merely being part of the family baggage, as it were. But almost as soon as that case was decided, it had very profound implications elsewhere, and people suddenly realised that the ZH Tanzania analysis applied to all sorts of corners of the law and family law. And in consequence, ZH Tanzania became a much cited case in a way which I suspect would not have been predicted beforehand. So that I'm sure I'm sure that if the convention was to be implemented fully, it would have enormous impacts. Equally, I suspect we would not actually be able at present to predict what some of those impacts would be. But keep on plugging away.
Well, I'm sure we could just do that, keep plugging away for several more hours on these questions, but we can't. We have to keep to some sort of timing. It's been a fascinating lecture with some really interesting questions and comments from the audience. I feel I've got a much greater insight into the issues faced by children and young people in prison, and in fact how this feeds into the work that our legal team have to deal with and try and unpick in this rather complex world that seems to populate the issues around children. On behalf of everyone here this evening, can I just thank the Right Honourable Sir James Munby for his excellent lecture. All that remains for me now is to give a plug for the Howard League for Penal Reform, basically, just to remind everyone, actually, that the work that the organisation undertakes is only permissible with the generosity of its members and supporters, many of whom are in the audience tonight. If you aren't a member, could I encourage you to visit our recruitment stand, if I can call it that, outside, while you're sipping some wine and tucking into a canapé. And can I encourage you, please, most strongly, to join the Howard League so that some of the work that you've heard about tonight can continue. The support of our members allows our specialist lawyers, and you've heard from Laura this evening, to continue to advise and represent children and young adults in prison on a huge range of problems that they face. And, you know, some of those problems have been exposed this evening. So do visit our membership stand, do join, and please take the opportunity to chat amongst yourselves and perhaps chat with Sir James when he's outside, imbibing some wine as well. Thank you very much.